Why is understanding the divorce process in India essential? Let's dive into this. Divorce is a legal procedure that requires careful navigation. In India, depending on the basis of your marriage, you would follow either the Hindu Marriage Act of 1955 or the Special Marriage Act of 1954. It's crucial to comprehend this process to ensure a lawful and correct divorce. But don't feel overwhelmed. We're here to help you navigate these waters. Let's break down the steps of the divorce process in India. There are several legal grounds for divorce in India. Firstly, cruelty by the spouse. This can be physical or mental and even includes causing emotional distress. Next, we have desertion, which is when a spouse abandons the other without reasonable cause for a continuous period of 2 years. Another ground for divorce is adultery. If a spouse has a voluntary sexual relationship outside the marriage, it's considered adultery. Impotency or physical incapability is also a valid ground. If a spouse is unable to perform sexual intercourse, it could lead to divorce. Mental disorder is another ground. If a spouse suffers from mental disorder or insanity, it can be a reason for divorce. Finally, there are also religiously acceptable reasons. These vary depending on the religion of the spouses. Once you understand the grounds for divorce, the next step is to choose a lawyer. It's crucial to find a lawyer who is experienced in divorce cases and can guide you through the process. Choosing an experienced lawyer who specializes in divorce cases is crucial. This legal expert will guide you through the process, explaining the law's intricacies and helping you understand your rights and obligations. The lawyer will also assist you in preparing the necessary documents for your case, ensuring that all details are accurately represented and in accordance with the law. The preparation of the divorce petition is a pivotal step. Your lawyer will craft this document, which will include details about you and your spouse, the date and location of your marriage, and the grounds for your divorce. It's important to be thorough and truthful in this petition as it sets the foundation for your case. Your lawyer will also include other supportive documents, like your marriage certificate, in the petition. After the divorce petition is prepared, it's time to file it in court. This marks the beginning of official legal proceedings in your pursuit of a divorce. The divorce petition is filed in the relevant family court. This legal document, prepared by your lawyer, presents the grounds for your divorce and is accompanied by supporting documents. Once the petition is filed, the court sets a date for the proceedings. The court then issues a notice to your spouse, giving them information about the divorce petition. This notice serves as an official intimation of the divorce proceedings. Upon issuing the notice, the court offers both parties an opportunity for reconciliation. The court provides a chance for reconciliation to both parties. This phase, known as counseling, is an attempt to help the couple find common ground and potentially save their marriage. A counselor, appointed by the court, facilitates these discussions, aiming to resolve differences. However, if reconciliation proves to be impossible, the divorce proceedings continue to the next stage, the hearing. At the hearing, both parties are given an opportunity to present their case. This is where all the evidence, supporting documents, and arguments for the grounds of divorce are brought to light. Each party, usually represented by their respective lawyers, voices their side of the story. Following the hearing, the court deliberates and makes a decision on the divorce. This judgment is based on the legal grounds for divorce, the evidence presented, and the arguments made. Once the court approves the divorce, a decree is issued. After the court's decision, there is a mandatory waiting period before the divorce is finalized. Under the Hindu Marriage Act, a 6-month period is required to allow for any possibilities of reconciliation. This is a time for contemplation and reconsideration before the final step. Once this period has passed and the process has been completed, the divorce decree is obtained from the court. This is the final document that legally ends your marriage. And that concludes the process of divorce in India. Let's recap the main points of the divorce process in India. It begins with understanding the grounds for divorce, selecting an experienced lawyer, and preparing the divorce petition. This is followed by filing the petition in the family court, undergoing counseling, presenting evidence at the hearing, and finally, receiving the court's judgment. A mandatory 6-month waiting period precedes the issuance of the divorce decree. Helpful tip: mutual consent can simplify this process. Remember, it's always beneficial to consult with a legal advisor for any kind of assistance.